Welcome to American Law Café. You know, we're always told that a signature is a promise, but what happens when that promise is actually a trap? When a deal is so lopsided, so outrageously unfair that it just shocks the conscience? Well, today we're going to look at the law's ultimate safety net, the doctrine that lets a court look at a signed contract and just say, nope, this isn't justice, and literally tear it up.
So here's what we've got on tap. We'll start with the hidden trap in contracts, then reveal the law's secret weapon to fight back. We'll show you how to spot an unfair fight, look at some real cases where justice was served, and also see when this legal shield, well, when it doesn't work. And we'll wrap up with a legal toolkit you can take with you.
All right, let's jump right in. Section 1, the hidden contract trap. I mean, this is a problem that's basically as old as buying and selling stuff. You know, from the time we're kids, we're taught that a contract is a sacred promise. Your signature is your bond, right? But let's be real. In the real world, not all promises are made between equals. And sometimes, that signature you just put on the dotted line, it isn't a symbol of a fair agreement. It's the sound of a trap snapping shut, a trap that's been carefully set with super dense legal language and clauses buried deep in the fine print.
And this creates this huge tug of war for the legal system. See, on one side, the law absolutely loves the freedom of contract. It's all about letting people make their own deals, good, bad, whatever. But on the other side, the law has this fundamental duty to protect people from getting cheated, exploited, or just plain oppressed. So it's this constant balancing act, right? Freedom versus fairness. So how does the law possibly solve this puzzle? Well, it has this incredibly powerful and kind of overlooked tool in its arsenal. You could almost call it a secret weapon. It's a big word, unconscionability. The best way to think about it is like the law's emergency brake. It's a doctrine, and you'll find it right there in the Uniform Commercial Code that basically gives a judge the power to step in when a contract is just so one-sided, so oppressive that, no fair-minded person would ever agree to it. It has to be shockingly unfair. And I love this because this quote is from the official comment to the UCC itself. It spells out the whole point of the doctrine. It's all about preventing two things, oppression and unfair surprise. And those are really the two key ingredients. Oppression, that's all about one side having all the power and exploiting it. And unfair surprise, that's the classic hiding the nasty stuff in the fine print trick. Those are the two evils this whole doctrine is designed to fight.
Okay, so if oppression and unfair surprise are the bad guys here, how does a court actually spot them in the wild? What are they looking for? Well, they're looking for two specific kinds of evidence that, when you put them together, paint a pretty clear picture of an unfair fight.
The court basically splits its investigation into two big questions. The first is procedural unconscionability. That's all about how the deal went down, the whole process. The second is substantive unconscionability. That's about what the deal actually says, the terms inside. And here's the key. Most of the time, courts need to see a little bit of both to step in and call a contract unconscionable. So let's dig into that first part, the procedural side. The court is basically asking, was the negotiation itself fair? They're looking for oppression. Was there a massive imbalance in bargaining power? Think a huge company versus, well, just a regular person. Was there any real choice? Or was it just one of those take it or leave it deals? What lawyers call a contract of adhesion. And then there's that unfair surprise. Were the really terrible terms buried in tiny font on page 47? Or maybe one person just couldn't understand the contract because of a language barrier. All of that is about the process. Then the court flips the contract open and looks at the substance. What does this thing actually say? Are the terms just a little tough, or are they totally harsh and one-sided? Is the price just a bit high, or is it completely, grossly excessive for what you're getting? Does the contract basically say, oh, and if we mess up, you can't sue us or get any evidence? Things like that, especially one-sided arbitration clauses, are huge red flags for substantive unconscionability. Okay, theory is one thing, but this stuff really comes alive when you see it in the courtroom. So let's look at some real cases to see how this all plays out. First up, we've got a total classic, Jones versus Star Credit Corp. The story starts out pretty simple. A family who happens to be on welfare and doesn't have a lot of financial expertise decides they need to buy a home freezer. Now, the freezer they picked out, at most, it had a retail value of about $300, okay? $300. Burn that number into your brain because that's our baseline for what a fair deal would have been. And here is the contract price. With all the financing charges and fees tacked on, the total price ballooned to over $1,400.
That's not just a bad deal, that is straight-up exploitation. The price was so ridiculously excessive that the court said it was unconscionable on its face. It's the perfect storm. You've got the substantive problem, the insane price, and the procedural problem, the huge inequality in bargaining power. And believe me, the Jones case is not a one-off. You see this pattern pop up everywhere. Take Ferguson versus Countrywide. Here, the fight was in the workplace. A court struck down an employment contract because it forced employees into a totally one-sided arbitration process with crazy costs. Then you have Frosty Fresh versus Reynoso, where a seller totally took advantage of a Spanish-speaking couple using misleading terms and a jacked-up price. That's a classic case of unfair surprise. And in the Fleet case, a company used deceptive ads to charge vulnerable people insane fees for services that were almost worthless. See the theme? It's always about protecting people who are in a vulnerable position from these fundamentally unfair deals. But, and this is a really important but, this legal shield is not a magic wand. It is not a get-out-of-jail-free card for every single bad deal you might make. There are limits, and it's absolutely crucial to understand what they are. So to really see these limits in action, let's put the Jones freezer case side by side with another famous case, Zapatha versus Dairy Mart. Now, in Zapatha, a franchisee's agreement gets terminated. He cries foul, says the termination clause was totally unconscionable. But the court said not so fast. So why was this case so different? Well, for a few key reasons. First, that termination clause, yeah, it was tough, but it was also crystal clear. It wasn't hidden away in the fine print. Second, the franchisees weren't like the family in the Jones case. They were experienced business people. And third, they were actually told they could, and probably should, have a lawyer look over the whole thing. The bottom line? The court looked at the facts and found zero oppression and zero unfair surprise. The law just won't save you from a tough bargain if you walk into it with your eyes wide open. And that Zapatha case also helps us highlight a really critical distinction. It's unconscionability versus the duty of good faith. Think of it like this. Unconscionability is a snapshot. It only cares about how fair the deal was at the exact moment it was signed. But the duty of good faith and fair dealing, that's more like a video. It looks at how the parties behaved and if they were honest with each other during the life of the contract. So in Zapatha, maybe Dairy Mart wasn't being very nice when they terminated the franchise, but they were following the rules laid out in the contract. So not unconscionable and not bad faith. All right, we've covered a lot of ground. So let's wrap this all up and give you some practical tools to put in your legal toolkit. Okay, if you're ever looking at a contract and your spidey senses are tingling, here is a super simple checklist to run through. Just remember the letters OPS. O is for oppression. Ask yourself, was there a huge inequality of bargaining power here? P is for price disparity. Was the price just shockingly out of whack with the actual value? And S is for surprise. Were the nasty terms hidden, buried, or misleading? If you can check those boxes, oppression, price surprise, you are definitely on the trail of an unconscionable contract. So what happens when a court actually finds a contract is unconscionable? What can it do? Well, it has a ton of power, a lot of flexibility. It can use a sledgehammer and just refuse to enforce the entire contract, throw the whole thing in the trash. Or it can be more like a surgeon, carefully taking out just the single unconscionable clause and leaving the rest of the deal intact. It can even reform or limit a clause to get to a fair result. Remember the Jones freezer case? That's what the court did there. It basically reformed the price. So at the end of the day, while freedom of contract is, a huge cornerstone of our law, it is absolutely not a license to oppress people. The doctrine of unconscionability is there to make sure that justice isn't just about mindlessly enforcing words on a page, but that it's about fundamental fairness. It's a really powerful reminder that behind every signature, there has to be a conscience. And that's our look at unconscionable contracts here at American Law Café. If you enjoyed this explainer, please do like and subscribe for more. And you can find us anywhere you get your podcasts.